Now go to the gentleman from Virginia, Mr. Cline.
Thank you, Mr. Chairman. I want to thank you for holding this hearing. I'm glad to see it's part one, and there are going to be many more to follow. But when it comes to intellectual property, the Chinese Communist Party has been eating our lunch for many years across both parties' administrations. I wrote down they're eating our lunch. Now I think it needs to be changed to they've been stealing our lunch money and parading it in front of us. But we're in the Biden administration, so let's talk about the Biden administration. Their own policies are further gifting the CCP with more ways to steal IP from American innovators and companies. 3 ways in particular: ending the DOJ's China initiative, supporting the WTO's TRIPS waiver, and the FTC's recent proposed rule regarding non-compete agreements. First, I want to go to Mr. Evanina, and let's talk about the China initiative. Last year, the Biden administration shut down this initiative, begun during the Trump administration, a national security program focused on prosecuting IP theft by Chinese government agents. In the weeks leading up to this decision, Director Wray called China the biggest threat to U.S. security. Would you agree with that assessment? And can you talk about the national security implications for the U.S. If China continues to achieve its goals to move into the aerospace, pharmaceutical, and information technology spheres?
Congressman, thanks for that question. And I would proffer by saying there is no extent to hyperbole when it comes to the Communist Party of China. And eating our lunch is probably minimizing the risk in the theft. And I concur with Director Wray and anyone else who talks about the reality and the facts behind what we see here. To address your China initiative issue, my information is that that was a decision to change the name of the initiative, right? So from what I understand, the cases continue. There's still over 1,000 Chinese cases of economic espionage, theft of trade secrets, and intellectual property that continue today. That was probably a political decision to satisfy constituents and get rid of the word name Chinese. But the issue continues to bear fruit. I do think that this is a whole society approach to defending what we're seeing every day, and it's going to take Congress and the entire country to help mitigate the threat.
Thank you. Mr. Cohen, let's talk about Chair Lena Khan's announced rule that would prohibit non-compete agreements nationally, coming on the heels of California weakening or eliminating the enforceability of non-compete agreements, which China has, as we know, capitalized on. In your article, The FTC's War Against U.S. Technology Competition with China, you wrote about the relationship between non-competes and trade secret protection. And can you talk about that, and can you talk about instances where California's refusal to enforce non-competes has affected trade secret protection?
Yes, thank you very much for your question. To get to the second part of your question first, I draw your attention to a case involving Gerald Yin who was formerly at Applied Materials. He went to establish his own company in Shanghai with about 30 other Applied Materials employees to engage in semiconductor manufacturing equipment. Mr. Yin has, I believe, according to a Wall Street Journal article, was placed on the entity list by the Department of Commerce last October. This is a critical technology. It's directly competitive with our own companies, and it would enable China to produce leading-edge semiconductor equipment. See, I have no problems domestically with non-compete agreements, if that's what the country wants to do. I have a problem with facilitating poaching of U.S. employees by foreign companies overseas. And I think this could actually create a great risk for the CHIPS Act. We're going to see several large fabs built in states which enforce non-compete agreements, not in California, regrettably. But if you can imagine TSMC sending a whole team of its best employees to Arizona to build a state-of-the-art fab, a Chinese company comes along and says, I'd like to bring out a team of 30 of your best employees to China. And there's nothing to stop that if non-compete agreements are invalidated. So there's an important deterrent effect. The other thing is that trade secret litigation is usually after the fact, after the stuff is stolen. It's rarely granted as a matter of a preliminary injunction. So you're basically in a position where whatever remedy you got may be inadequate to address the loss. And that's part of the reason non-compete agreements are the most effective, your first question. Because by being able to prosecute a non-compete agreement, you don't have to prove that there's a trade secret. You just have to prove that there is a violation of the obligation to not work for a competitor. This also mitigates the risk of secondary loss, which happens in a trade secret case when you reveal your confidential information to a court or to an administrative agency. You don't want to have that happen, and that's one of the reasons that some companies don't want to bring trade secret cases, because they're afraid there will be a secondary loss. So a non-compete agreement is easier to enforce, it's cheaper, it mitigates the possibility of secondary loss, and as I mentioned earlier, the chances of success, if you were to bring the case, for example, in China, and I believe in most other countries in the world which permit non-compete agreements, are much higher than if you were to litigate a trade secret case, and less expensive.